Let's talk about oil and gas division orders. A division order is a legal document. It's an agreement between the operator of a well and the mineral owner so that everybody's on the same page about what the mineral owner owns and how much interest they own. A division order is sent to not all mineral owners. It's really an industry best practice. In some states, like in Texas, it's absolutely required. You have to sign a division order in order to get into pay status. And that means you'll start receiving checks on your oil and gas well. In other states like Oklahoma, it's something that's done a lot, but it isn't required by their laws and statutes. So there's times when operators they skip it and you don't even get division orders. So it's it varies based on the state that you're in. But the thing that triggers a division order is anytime a new well is drilled or there's a change in ownership. So when you inherit minerals from, say, your mother or your grandmother, then you're going to get a division order. And you won't get checks usually until that division order is signed and turned back in. That depends on the state. The other thing is if it's a new well is drilled. So sometimes when a new well is drilled, but it's drilled under the lease and you already are being paid on other wells, you may or may not get a division order for that. Sometimes they will pay you regardless and sometimes not. So there's a lot of maybe, and it depends with division orders, but generally speaking, you want to take them seriously because they are a legal document and you are agreeing that you own interest in this well and a certain amount of interest. And if that's wrong, then there's consequences. It could be wrong and they might be paying you not nearly as much as they should be. And maybe that will be caught sometime in the future, but this is a good opportunity to catch errors. And sometimes it's just was typed in wrong, like it's 0.002786 and it should have had 3 zeros in it, or should have had 1 zero in it. Those are just human errors that happen sometimes. Sometimes it's been miscalculated for a long time, and that's only discovered when you go through and you do your own calculations, and then you can talk to the operator and figure out why you guys are not on the same page with the calculations. If it's later discovered that the operator has overpaid you, you may go for months or years with no royalty revenue while they try to balance that account. But the bigger issue is if your decimal interest is incorrect on the division order, and there's a term in the agreement where you have agreed that if there's an error, that it's on you and that you're assuming all the legal costs associated with that, including their legal fees. You really, really want to be careful about signing something like that, especially when you're not 100% sure of what you own. And it's really hard to know if it's correct because most mineral owners, they get a division order out of the blue, or they just inherit minerals and they don't really know that much about it. So it seems like it's unreasonable for the operator to expect the mineral owner to really understand how the calculations work and how much they own. So it's of course in your best interest to hire a landman and figure out what do you really own before you sign this division order. The reality is that most people don't do that and they just sign it and then deal with the consequences. So if you're going to do that, then know what the consequences are. And when you look through those terms, look and see, is there any language in there that makes you legally responsible for their errors? So there's another term that's often in division orders, which I won't sign a division order with this. So it's a little bit hard to explain. One of the main things that's negotiated in an oil and gas lease is the deductions for natural gas. Because operators, so natural gas, it's not like a marketable straight from the wellhead. So it has to be compressed, it has to be cleaned. There's all different kinds of things they do to the the natural gas to get it ready for market. And it didn't used to be this way, but now operators pass those costs on to the mineral owner. So a lot of times, one of the main things that is negotiated in an oil and gas lease is a cost-free lease, which means that the operator cannot pass those costs along. If you have a cost-free lease, and then you turn around and you sign a division order that allows the operator to deduct any costs, then you're just reducing your royalties. And it can be significant. Some operators are only taking like 20 to 30% of your royalties in deductions, and others are taking up to like 70, 80%. So it can have a really dramatic impact on how much you earn. Of course, you might have a lease that allows for costs, and your division order may also allow for costs. I don't like signing a division order with that language. So what do you do if your division order has language in it that you object to? There's actually a really easy solution for this. So the National Association of Division Order Analysts have created a model form, and you can just Google this, or I'll link it below. And you can use this model form most of the time and submit it in place of your division order, and most operators will accept it. I have about 130 operators, and I think I've only had a problem sending the model form division order maybe with 2 of them. So the vast majority will accept it, and it's fine. So you just take the information from your division order and you put it on your model form division order. And they're similar enough that it's really obvious and easy to do. The division order is going to have like 3 main parts. One is the property info. This is the name of the well number, the legal description. This is so that everybody's on the same page about what property are we talking about. And sometimes it talks about whether it produces oil or gas or plant products or other products. The other section that's important is the owner section. And that's going to have your owner number. It will have the owner of the minerals, and that may be you. It may be a trust. It may be a company. So it just depends on how the minerals were deeded or transferred. And the third really important section is the terms of your agreement. And so that's why I usually recommend the NADOA model form. It's just going to protect you from some of the language that is in a lot of the division orders that you'll receive. So overall, the division order is a legal document. It's sometimes required, especially in Texas. It would be in your best interest to either calculate it and make sure that it's correct, or to hire somebody who can help you calculate it and make sure it's correct. It's also usually in your best interest to send the model form, the NADOA form, instead of the form that the operator sends to you. However, some operators use that NADOA model form, and so their language, it might be like a little bit different, but the language is still the same sometimes. So if I see that, I'll just send their form back. It's fine. But if they've got some interesting language in there, I'm going to use the model form.